Hey folks, Attorney Sharif Silmi. Those of you interested in self-petitioning and have a technology background, I really want you to pay attention. There is a very, very important document that's issued by the National Security Council. It's called the CET, the Critical and Emerging Technologies List. And I believe this list and this document is very, very important for anyone who is self-petitioning, whether they're doing so in an EB-2 National Interest Waiver category or in an EB-1A Extraordinary Ability category. And the reason is, in both of those categories, you have significant importance assigned or ascribed to the national interests of the United States. So if we look, for example, in the NIW context, the Danisar case talks about one demonstrating that they have a proposed endeavor that is of national importance, right? So when we look at the term national importance and contextualize it within the framework of one who is in a STEM or technology-related field, the USCIS policy manual actually specifies that one who is working in a critical and emerging technology does have an advantage in terms of their ability to demonstrate national importance within that context. So it's very important that the proposed endeavor be specific. And where we have seen some changes in adjudication over the past year or so, it is in that particular area that we need to demonstrate that the proposed future endeavor that one is going to engage in must be highly specific. And what we mean by highly specific in the context of a national interest waiver is not simply saying that, for example, I'm going to work in rather than say, for example, I'm going to work in cybersecurity, you might say I'm going to work in access management, right? Like that's a more specific domain within cybersecurity. That's actually not the specificity that USCIS is looking for. What they're looking for is a description of the actual projects that you're going to be working on. That is to say, for example, I am going to be developing the access management security protocols for XYZ company over the next 3 to 5 years. This is the importance of that company within the, greater economic and security, ecosystem, and explaining that to the adjudicator in the context and how this particular project is going to be important within the industry and as it relates to national importance, right? So that is actually what we're looking for in terms of the proposed endeavor being of national importance. It needs to be impacting the industry. It needs to be specific at a project level and have, basically impact beyond the employer or company where it is being performed. So the same thing translates over into EB-1A. Within the statutory requirements of EB-1A, you understand that it talks about one must demonstrate that they will provide prospective benefit to the United States, that they're going to bring about future benefit to the U.S. Now, future benefit to the U.S. is really, really important because at the end of the day, whether we're talking about an EB-1A or a national interest waiver, we are filing an I-140 petition. And if nothing more, an I-140 petition is an application for permanent residency based on employment, right? It is essentially saying to the United States government that, hey, I am a person who's seeking permanent residency because I plan to live permanently in the United States. So in doing so, you need to specifically articulate what exactly you will be doing in the future. That is true of both the National Interest Waiver and EB-1A. So when we talk about prospective benefit to the United States, we need to actually lay out a plan of future activity of what you will engage in and how that relates to a critical and emerging technology gives you an enormous advantage as it relates to the final merits determination within the EB-1A context. So if you are thinking about EB-1A, and the need has never been greater for many of you who are on H-1B and EB-2 backlog, you need to think beyond simply demonstrating how do I meet particular criteria. Sure, we can help you meet membership. We can help you meet judging. We can help you meet critical role. We can help you develop original contribution, major significance arguments. But at the end of the day, you really need to meet the final merits determination. And one of the ways that I think it's important to do so is to talk about what you will do in the future and how the future work that you'll engage in is going to be at the very highest level of your specified area of endeavor. This is, a really part of our uniquely tailored approach to developing self-petition cases, and one of the reasons why we've been seeing a very high level of approvals throughout the year and in past years, of course. So we anticipate this being a central part of our strategy going forward, to articulate not only what you've already achieved and how that has already impacted the field, the specific area where you are claiming extraordinary ability, but also to talk about what you will be doing in the future and how you'll continue to work in the particular and specific area where you are, have established your expertise and abilities. So I hope this is really helpful and kind of gives you a new way to think about approaching EB-1A as not only discussing your past and things that you've already achieved, but also articulating to the government what you intend to do going forward, because 2 of the 3 statutory requirements, not the regulations, the statutory requirements that relate to EB-1A have absolute and total reliance upon future activity, that you will make prospective benefit to the United States, that you're going to bring out future benefit to the US, and that you'll continue to work in your specified area of endeavor. So I hope this is helpful to give you a little bit of a context into what a uniquely tailored case might look like. Please reach out to us. We'd love to talk to you about your case.